get underway. Okay, so thank you everyone for joining us tonight. So my name is Gregory Ho. For those who don't know me, I'm a lecturer at Edith, Cowan University in health and safety. And joining us also is Sam Whitten, who's calling in from Victoria. And he's a senior associate with law firm Safepath Shaw. So it's our pleasure to welcome you to our webinar, and also our thanks to the Safety Institute of Australia for hosting this session. So let's get underway. What we're going to do is cover these 6 areas here. I'm going to spend about 5 to 10 minutes on each topic. We'll try to go through it relatively quickly so that we'll have about an hour for this. I'll take you through the first 4, and then Sam will take you through the last 2 here. What I'd like to encourage you, though, is to ask questions at any time by using the chat function at the bottom of your screen. So have a look for that now. You might have to move your mouse down to the bottom of the screen, and you'll see a chat function, and you can chat to everyone. And then you can just ask questions at any time, and we'll stop to answer those. If we are running a bit short on time, we might just try to leave the questions to the end. We've got an extra half hour at the end for questions. So let's just test this out at the moment. Can everyone still hear me okay? If you can, just type in yes into your chat function. Let me know how it's coming through. Also let me know that it's still going. Okay, great. All right, so let's get straight into it. All right, so part 1, harmonisation. So it is an exciting time to be in the world of OHS. You know, especially in WA, where it's currently going through modernisation of the work health and safety laws to match the model work health and safety acts. And also is happening is a review of the model work health and safety laws by Marie Boland, who's doing that around Australia. So it really is a good time to run this type of lecture and get up to speed with what's happening in WA and harmonisation in general. So what is harmonisation? So basically it's when all the states and territories in Australia have a consistent set of health and safety laws. And by that, we don't mean that they're identical, but what we mean is that they're similar. So the laws really acknowledge that each state and territory is unique in terms of what its properties. So like in WA or in Queensland, they're known as mining states, where most of the revenue comes from that industry. Whereas Victoria, most of it comes from small business. So what harmonisation means, it doesn't mean that everyone is forced to use the same laws, but comes from the same template. And that template is what we call the Model Work Health and Safety Act. And that can be modified and tailored to suit the individual needs. So that's what's happening at WA in the moment. WA's had a look at the Model Work Health and Safety Act, and it's currently making amendments and getting feedback from the public. Okay, so and all this happened following the 2007 federal election, which saw a swing towards harmonisation. So if you don't remember, that was the Howard versus Rudd election, and which Rudd was gained power. And about a year later, all the premiers got together for what's known as COAG, the Council of Australian Governments, to sign an agreement to harmonise work health and safety of Australia. So what we have now is this. This is the current state of harmonisation. So you can see here, on the 1st of January 2012, most of the states and territories, as well as Commonwealth departments, produced their own Work Health and Safety Act. Although they've got the same name, like I said before, they have been tailored to be unique for that state and territory. So at the end of the full title for this one, for ACT, would be Work Health and Safety Act 2011 in brackets ACT. All right, and so on for all the states and territories in the Commonwealth. And exactly a year later, Tasmania and South Australia came out with their one, which was the 2012 Act. And what's happening in WA at the moment is it's in a process of a reform, and its indications are that it's likely to be sometime in 2019 introduced to Parliament. So we'll talk about a bit more on that later. And Victoria's Act, which is the Occupational Health and Safety Act 2014, they are not going to harmonise, and they have stated that they don't intend to. Their one is actually the most modern of all the acts before harmonisation. All right, so a lot of what they had went in to produce the Model Act. And for that reason and others, which we can discuss later, they've chosen not to harmonise. So what we have here is this sort of traffic light system. So all the green states and territories are the ones who have adopted the Model Work Health and Safety Act, whereas WA, not so much a question mark anymore. It's probably more when than if, and Victoria is not going to. So in terms of when we talk about WHS versus OSH, that acronym, we have most of Australia using WHS now. WA's Act is still OSH, whereas Victoria is OHS. All right, so Occupational Health and Safety, just to make it a little bit more interesting for you. All right, and also, if those who are interested, New Zealand, theirs is called Health and Safety at Work. So theirs is HSW. All right. So, so if you have any questions on that, just please let us know. But that's the current state of play at the moment. There's a roadshow going around at the moment, and they've indicated that the WA's version will be 90% similar to the WHS bill, the 2016 version, and indications are that the name will change to become the Work Health and Safety Act as well. So after that, if that happens, when that happens, that will become all green, and Victoria will remain red. Okay, so are there any questions on that so far? Can I move on? Am I going too fast or too slow? Just let me know. Just type in, and we'll keep going. All right, so that's harmonisation in a nutshell. I hope that makes sense. Okay. All right. So let's step back a bit and discuss what is law. So bringing it back to basics. All right. So there's this quote in this play which says, "Without law, men are beasts." And that brings us to the definition from the Oxford Dictionary, which states that law is a system of rules and guidelines which a particular community or country recognises as regulating the actions of its members, which may enforce by imposing penalties. So the key terms here are regulating its actions and having the right to enforce penalties. And that brings us to this image of Lady Justice, the Roman goddess of justice. And you'll notice that there is a lot of symbolism going on here. So she's got these scales, the blindfold, and the sword. And you can probably have a good idea, even if you haven't seen this image before, of what those symbols mean. So the scales, that, if you're looking for justice, it'll be balanced. It doesn't matter how much power you have or your status in society, you'll be judged fairly. And also there's the ability of the courts to enforce penalties and, if necessary, imprisonment and loss of liberty and so on. Okay, so if you can think of the types of law, and I am going through this quite quickly, but if you can think of this way in terms of how laws are created, there's two ways. So one is statute law and one is common law. So statute law are made by Parliament through Acts of Parliament, and common law is judge-made law. Okay, so you've got here that what's happening in WA at the moment is the Model Work Health and Safety Act is being produced by, I've got a picture of the Parliament House of Western Australia, and also the common law is the Supreme Court of WA as well. So, these are the two ways in which laws are produced. And just the example is the OSH Act in WA was produced by the government here in Parliament. Now, if you can look at law in terms of two categories as well, you've got civil law and criminal law. And civil law deals with individuals. So you can think of when one person is suing another person or an organisation, that's under civil law. And criminal law are offences against the state, and that's what deals with crime and legal punishment of criminal offences. And so you can see here the little diagrams here. Sorry, I had some pop-up message come on here. All right, so you got the plaintiff versus the defendant, and the plaintiff is looking for reimbursement for damages or loss, whereas criminal law deals with going against the state and possibly going to prison and loss of liberty there. All right, so I hope that makes a bit of sense. So in terms of the OSH laws, bringing it back to OSH, OSH laws are both a statute and criminal laws. So the Occupational Safety and Health Act, WA, is a statute. So it's a document. You can actually get in a book form. Whereas breaches of the OSH Act are a criminal offence. So breaches of the Act or the regulation criminal offence. So it's nothing to be sneezed at here. So you've got a combination of statute law and criminal law. That's why it's really important when we talk about the OSH laws and work health and safety laws, that it is really important, and it does affect everyone in the state. Right? So that's why it's really important that people understand about what's being introduced into WA at the moment. Okay, so I think we're keeping with the time relatively okay. So I'm going to go on to the pyramid of legislation. So again, do feel free to ask questions at any time. But this is the pyramid of legislation here. So we've got acts, regulations, codes of practice, and guidance materials. So codes of practice are guidance materials, but you can sort of see it as a pyramid structure here. To provide some examples now, so under acts, we've got the OSH Act, WA. Regulations, we've got the OSH Regulations, 1996. And codes of practice, for example, we've got managing noise in the workplace. And under guidance materials, we've got safety alerts. Now, if you think of the top two as being what we call law, so these are legally binding, these top two, and the other ones are supporting materials. Okay, so if you talk about breaking the law, you're talking about acts and regulations. So an act is a piece of legislation that has been passed or enacted in Parliament and is law. So we talk about statutes there, and they impose mandatory obligations on duty holders to comply with general duties defined in the Act. All right, so for example, there are duties on employers and employees, which we'll look at. So employers need to look after their workers by doing what's reasonably practicable, and we'll discuss that in a moment. In terms of regulations, so these are one step down from regulations, but still legally enforceable, and these provide more clarity for the acts. So same legal force as the acts, but provide more detailed information. And typically, regulations are 3 times as big as acts. So I've put these two images of books together. As an example, if you have a look at the OSH Act, it's 160 pages long, whereas the regulations are 341 pages. I did a bit of a look at this one. So it's roughly 2 times larger, 2.13 times larger than the Act. So it provides the detail that's not contained in the Act there. So that's the regulations. So codes of practice. So like I said, they're guidance materials, and they provide a practical guide to achieving the standards of health and safety required in the acts and regulations. So they're not law, but can be used in court as evidence for or against. So it can be used as evidence as to what is known about a hazard, risk, or control, and to determine what's reasonably practicable in controlling a specific hazard. And what we mean by specific hazards, like things like manual handling. So this is the WA one for manual tasks. And I think this is out. I thought I did get this from the website. They're no longer called the Department of Commerce anymore. So I think they just need to update that one. All right. And then finally, we have other guidance materials such as standards, guidance notes, international materials, and these provide practical guidance on how to meet legal obligations, mainly for employers. Right. So this is an example of a safety alert that's produced not long ago. Worker seriously injured by flammable liquid fire. All right. So it's got some details about what happened so that everyone can learn from that. So that's a new term. There you go. Department of Mines, Industry, Regulation and Safety. Okay. So how is an act created? So before it becomes an act, it's called a bill. Bill is basically a draft act. So you might hear the term Work Health and Safety Bill or Model Health and Safety Bill. So it's the draft, and it's usually presented to Parliament by the Minister with an explanation of what it intends to produce. And then it goes through a period of public consultation, and then it goes through parliamentary debate. So you can see here this roadshow that has been held around the state recently, and it says here, so the public consultation period closes on the 31st of August 2018. So this, at the moment, this model bill is going around for comment, and you can have your opportunity to have a look and make comment as well. So the parliamentary process, so once it's had that, it goes through the upper and lower house. So in Western Australia, the Legislative Assembly and Legislative Council, and 3 readings in both houses. So it's quite a thorough, review, bounces from house to house. And then when it's passed by both houses, that state law publisher produces a vellum that is brought to the Queen's representative, which is the governor, or for the federal law, it's the Governor General. So still has that old sort of British colony type thing. So it needs to have royal assent by the governor or the Governor General on behalf of the Queen. So in theory, the Queen can say, no, I don't agree with this law, and decline it, but it's never been done for obvious reasons. And then an act is born. So there you go. So this is what we call that, the parliamentary process. So it goes from the lower house to the upper house, bounces back and forth 3 times between the 2 areas. Okay, so that's part 3. Now, part 4, the key OSH terms. So these are terms which you'll hear a lot, and it's important to know what they mean. I'm just going to cover three key terms. So hopefully, if you get nothing else from tonight, you have some understanding. You have heard of these terms before. So the first one's reasonably practicable, and this applies to employers. Or the new term for employers is a person conducting business or undertaking, or PCBU. So that's a term in the Model Work Health and Safety Act to replace employers. And what that states is, reasonably practical is what is reasonably able to be done in relation to ensuring health and safety, taking into account and weighing up all relevant matters. So as an employer, you've got the responsibility to look after the health and safety of your workers, and you have to take in all relevant matters and weigh them up. All right, so I'll give you some examples, but that considers 5 things. So the likelihood of a hazard or risk occurring, a concern occurring, the degree of harm that may result. So what the person knows or reasonably ought to know about the hazard or the risk, and ways of eliminating and minimising the risk. So this is what the employer should know if they don't know. And the ways and suitabilities, the availability and suitability of ways to eliminate or minimise the risk, and the cost. So the cost associated with available ways of eliminating and minimise the risk, including whether the cost is grossly disproportionate to the risk. So it's a bit wordy, but let's try to put into an example here. And I try to be a little bit more relevant and current. So this is the Thailand cave rescue. So let's assume that these people are not, not volunteers who get awarded medals by the Prime Minister, but say they're employers of a company, and their job is to, their job is to get these children out, but also to look after the health and safety of themselves as well. Their employer needs to consider the likelihood or the risk of something occurring. So there's obviously dangers involved with that. The degree of harm, so the consequence. So that could be, the consequences are from what we know now is that very high chance of death doing this cave diving. So the employer should know about the hazard or the risk, as well as ways to eliminate the risk as well. So if we look at Elon Musk's idea here of producing this, say for example that wasn't a new idea, but something that all cave divers used, and it's relatively affordable. The courts may ask, why haven't you used this? Why haven't you invested in this sort of technology when everyone's using it? We know that's not the case, but just for example. And the cost as well. So the cost is always considered as well. if it's grossly disproportionate, but cost is the final consideration. So you need to look at all these other things first. Right? So on the balance. Okay, so I hope that makes sense. So just two examples here. So in terms of reasonably practicable, I had a student write in the exam paper, like the question is, how can you protect your workers from the sun if you're working in a hot environment? And the student wrote down, you can provide everyone with spacesuits, air conditioned spacesuits, so they're protected from the sun. We know the sun has some devastating consequences. You could die, you could get heat stroke, skin cancers, heat exhaustion. But if you look at whether it's reasonably practicable, it's perhaps you're probably more inclined to look at some other options first, like providing shade and cool drinking water, hats, ventilated clothing and sunscreen, working in the cooler times of the day. So the cost of providing everyone with spacesuits who works in the sun would be disproportionate. Another example that's I got from Sam actually was that the risk of paper cuts for office workers. I think most of it, if not everyone, has suffered a paper cut. So that the likelihood of being injured, in inverted commas, is very high, but the consequences are low. I don't think anyone's sort of lost an arm or a hand from having a paper cut. I hope not. Someone out there going, "Yes, me," and waving their hand or their stump. The cost of making office paperless is maybe disproportionate. You can look. We're talking about OSH impact, not so much environmental impact as well. So in order to meet the duty as a PCB or an employer, it would be not considered reasonably practicable. Okay. So the second key term is reasonable care. So with the reasonably practicable, that was talking about being an employer or a PCBU. Reasonable care looks at duties on workers. So the Model Act says that workers must take reasonable care for his or her own health and safety, and defines reasonable care as the action or degree of caution a rational person would take for the safety of him or herself in the circumstances. So say you are at work and you cause an accident or you cause an injury to yourself or others. The courts may ask, what would a reasonable person do if he or she had the same knowledge, skills, and experience? So that's really the test here is what would someone else do in this situation? So what would your co-worker do, assuming that they have the same knowledge, skills, and experience? So it's a lower standard than reasonably practicable, but it still requires you to be, judged what a reasonable person would do. All right, so the final definition I'm going to talk about before handing over to Sam is due diligence. So we talked about reasonably practicable applying to employers or PCBUs. We talked about reasonably practicable applying to workers to each other, and due diligence applies to officers. And just note that officers is with a capital O. So it doesn't mean health and safety officer, even though they've got officer in the title. This is talking about people who are on the board of directors, the CEO, the company secretary, and so on. So they're required to meet their duty of care with what's called due diligence. So this is another new thing to a change to WHS Act. So this is taken from the Corporations Act in terms of the definition. So it says that even though you might be the CEO and have nothing to do in terms of the day-to-day running of a mine site or a factory, they are required to acquire knowledge and understanding of work health and safety issues, acquire knowledge and understanding of the operations of the company and associated hazards and risks, to ensure and verify the company has resources and processes to eliminate or minimize the risks of health and safety. So it comes down to the people who have the power to issue resources, being able to do that, to ensure appropriate processes for receiving and considering health and safety information and responding to it in a timely way. And the final one is to ensure the appropriate processes for complying with all the duties and obligations contained in the Work Health and Safety Act. So, like I said, people who, it's just acknowledging that people in power and have have some influence over the whole business, understand what the health and safety risks are, and devote appropriate resources to that. Okay, so it doesn't look like there's any questions. So what I might do is hand over to Sam now, who'll take you through parts 5 and 6, and then you can have further questions after that. So I'm just going to mute myself, and I'll hand over.
Thanks, Gregory. Leaves me to do the nasty lawyer part and talk about the what happens when goes wrong and the enforcement and penalty regimes. As we saw though at the beginning, when Gregory showed the symbolism of Lady Justice, part of that was the sword. And the sword is obviously about enforcement of penalties. So the enforcement regime is fundamental to all laws, and in the case of the health and safety laws that we have, it's a key part of preventing workplace deaths and injuries. So the functions of the regulators, the regulators have a range of functions, and we discuss both those from a proactive sense, where they have proactive enforcement measures, and a reactive sense used to encourage compliance and ultimately to prosecute where there's serious non-compliance. So regulators really seek to use a mix of proactive, positive measures, compliance monitoring and deterrence to encourage and secure compliance with the laws. And there clearly needs to be a balance in this, that as with all criminal laws, and it's important to remember that the work health and safety laws are criminal laws, that there will be a community expectation that people will suffer some form of detriment, that they will be held account and ultimately punished appropriately if they fail to comply with those laws. So the starting point is, what is the community expectation? And as Gregory has discussed, around the country, the laws have been harmonised to some degree, but they remain state and territory based laws. So we've got 9 regulators around the country, including the Commonwealth regulator Comcare, who looks after Commonwealth government departments and those people that are self-insured for workers' compensation purposes and therefore fall under the federal work health and safety scheme. So big employers such as John Holland, Biz Industries, Bankwest, etc., have become self-insured and are regulated in the federal regime. So there's separate regulators for each of the jurisdictions, and in WA, the key regulator for the general work health and safety regime under the OSH Act at the moment is WorkSafe, a division of the Department of Mines, Industry, Regulation and Safety as they now are. So important to bear in mind that the regulators around the country are separate, and they have similar, albeit not identical, enforcement and compliance policies. Part of the model laws was the introduction of a model compliance and enforcement policy that sets out the considerations that the regulators should take to how it will go about enforcing compliance with the laws. And really there are 2 key approaches, 2 tools. And I like to think of these really as a carrot and stick approach from the old metaphor of when we used to have horses and carts, dangling the carrot in front of the horse's mouth as a reward, and of course punishing by hitting the poor horse with a stick if it didn't do what the coach driver wanted it to do. And we can think of the way in which the regulators around the country enforce compliance with the health and safety laws in the same way. 2 buckets, a bucket with reward and a bucket with punishment or a stick approach. And the positive motivators, thanks Gregory, doing a wonderful job keeping up with the slides. The positive motivators include advice, education, providing updates, holding information sessions, all of the positive things that we see the regulator out and about doing. And that includes supporting health and safety representatives, so that health and safety representatives understand their role and understand the tools that they have to use in the workplace to assist with ensuring compliance with the Act. On the flip side, there are a number of deterrents, and the way that non-compliance is deterred includes by detecting and dealing with alleged breaches, undertaking inspections, audits and investigations of alleged breaches, taking appropriate enforcement action, seeking appropriate sentencing, so making submissions at the time of sentencing being imposed if a matter has been heard before the courts, and publishing the outcome of decisions, so a public naming of offenders and a public recording of what has occurred in particular matters. So the toolkit that the regulators has is pretty wide, both from a positive and a reactive perspective. Now, you can think of this really like a pyramid, in the same way that we had the pyramid of laws. We've got a pyramid of compliance and enforcement tools. And the reason that it's a pyramid is because the tools at the bottom of the pyramid are used much, much more frequently than those at the top. And the tools at the bottom are those positive, proactive, encouraging, and compliance type tools. And as examples, in Victoria last year, the health and safety regulator here undertook something like 45,000 positive, proactive inspections or engagements with businesses. On the flip side, it took 100 prosecutions, or commenced 100 prosecutions. And the scale of activity is similar in WA in terms of the split between proactive and prosecutorial action. So in WA last year, there was 7,500 investigations, 11,000 improvement notices, 278 prohibition notices, and 12 prosecutions. So without getting too bogged down in the raw data, it's very clear to see that the ultimate sanctions of prosecution are used relatively infrequently, and the bulk of the work undertaken by the inspectorate in the regulators is to use those encouraging and compliance tools that they have. So proactively engaging with businesses, providing information about what the law requires, conducting information sessions, all of those sorts of things. Now, as a sort of middle road to this, one of the enforcement tools that the model work health and safety legislation provides for is for enforceable undertakings in lieu of prosecution. In the OSH Act in WA, these don't currently exist. You can enter into an undertaking, but only in lieu of penalty once a matter has been before the courts. Whereas in the model legislation, it's a alternative to prosecution, that you agree with the regulator that you will undertake a particular project which will have a benefit to the industry, a benefit to the workplace, and a benefit to the community, and undertake that project instead of being prosecuted. Now, they can't be used for all offences. If it's a very serious offence, if somebody has died as a result of a workplace injury, the regulator won't consider an enforceable undertaking. But if it's a less serious matter where somebody has sustained an injury, but they haven't died, and there isn't an element of recklessness in the offence, and the corporate history of the offender is good, so they don't have a long criminal record, then the regulator may well consider an enforceable undertaking by way of in lieu of prosecution. And I'll give you an example of one of these, one that I've worked on recently, which is now up on the Regulators website, so is public knowledge because the enforceable undertakings get published. A mining drilling contractor in Victoria, in the goldfields in Victoria, worker's thumb amputated as a result of an incident with a drill rig. They have indicated to the regulator, and the regulator has accepted an expenditure in a safety behavioural program that will have benefits for their own workforce and benefits for the regional Victorian community. So that type of a project where they agree to fund education, develop materials that can be used broadly in the industry and in the community is the sorts of things that typically get accepted as enforceable undertakings instead of prosecution. The publication of the outcome of matters that go before the courts is an important compliance tool. I guess there's no greater concern for most businesses and indeed for most individuals than the reputational fallout which comes from being involved in a criminal matter. And obviously, if these things weren't reported at all, there would be much less impact, and arguably people would be much less concerned about complying with the law. And so the publishing of outcomes is an important tool. In WA, because most of these matters are heard before the Magistrates Court at first instance, it's rare for those decisions to be published in the law reports, and therefore the summaries that are published by the regulator are a really important source of understanding what has occurred in particular matters and what the penalties imposed have been. So that's a really useful resource. The regulators around the country have similar databases that can be searched to look at the penalties and the facts associated with a particular matter. So the ultimate sanction really is prosecution, and so legal proceedings can and are commenced in circumstances where a breach of the Act or regulations is alleged by the regulator, and there are time limits in which the regulator can bring those proceedings. Under the Model Act, typically 2 years, in WA at the moment 3 years, and I think that 3-year time period is proposed to continue in any new laws that we have. Those time limits can be extended in certain circumstances where new information has come to light or there's been a coronial inquest, for example. But typically there is a need for the regulator to investigate relatively quickly, although of course 2 or 3 years is a long time for these things to be hanging over people, not least of which any injured worker and their family. But these proceedings are commenced in circumstances where there is an allegation, and they run through the courts, the normal criminal courts, and a finding is made by the courts as to whether there has been a breach of the Act or not, based on the principles that Gregory was talking about reasonable practicability, and then ultimately a penalty can be imposed. Now, under the Model Work Health and Safety Act, the penalties are categorised based on the level of seriousness of the offence. So the most serious offence being a Category 1 prosecution, which involves a form of reckless conduct. And a recent example of that is a case in New South Wales' first reckless conduct case, where a lady was electrocuted whilst taking a shower at an accommodation associated with a mine site. The mine site had prior knowledge of electrical issues there. They knew that there were issues with the switchboard. Those issues weren't remedied, and ultimately energy flowed from the switchboard and made the shower fitting in the accommodation live, and unfortunately fatally injured the person that was using the shower. So that sort of thing, where there is knowledge about a particular risk to health and safety and that knowledge hasn't been acted upon, falls within that most serious reckless conduct category. The category below that is about offences where there has been a serious consequence, so where there has been a fatality or serious injury, or where somebody has been exposed to risk of fatality or serious injury. And then the last lowest category, just where there has been a failure to comply with, but it hasn't resulted in those more serious circumstances. And the penalties are, set out on the screen there. They're moderated, they're graduated, and they relate to both corporations, officers, as Gregory talked about, and workers. In WA, lower penalties at the moment in terms of the dollar and cents amount. They've been in place for quite some time, given the age of the Act that we have in WA. There has been a proposal to increase those penalties, and there's a bill that's floating around that's before Parliament that hasn't really gone anywhere to increase those penalties. I think we will now see those penalties increased when we see new legislation, and all the talk is that there will be potentially the highest penalties in the country in WA when we have new laws that are introduced there. Onto the last section, which was just to very quickly talk about recent developments in WA. Gregory has alluded to it, that there is a discussion version of the WHS Act out for public comment. When I say a discussion version, there is a discussion paper that says these are all of the areas that we in WA are likely to amend from the Model Act. That public consultation is open until the end of August. Look, I think it's a really great opportunity. Obviously, this debate has been going on for quite some time, but we're finally seeing what the laws are likely to look like based on Stephanie Myanmar's Ministerial Advisory Panel report. So there's some interesting amendments to the model, one of which for all of the health and safety professionals out there I'm sure will be of the most amount of interest, which is that there is a proposal to include an additional duty on providers of work health and safety advice. So that includes OSH professionals and, much to our chagrin in the legal profession, OSH lawyers as well, to ensure that the advice which is provided does not expose a person to a risk to their health and safety. Now, that duty doesn't exist in any of the other state and territories laws that have adopted the model. It was a proposal that was made at the time that the model legislation was drafted, but it wasn't adopted as part of the model, as part of the Ultimate Model Act, or adopted in any state or territory. So if WA adopts that, we will be the only jurisdiction to have that. Watch this space, I guess. I guess there is a bit of an argument that the general duty covers it. So, is there a need for a specific duty? Well, I guess it's a good idea to make it clear that people that are providing that advice do owe a duty. So watch this space. There's some other tinkering around the edges of the bill. There's some areas of sort of increasing worker involvement and engagement, and increasing the role of potentially unions and HSRs in the Act, as well. Really a reversion to some of the principles that were put forward in the model that weren't adopted in other jurisdictions. So there are some potential variations to the WA version of the Model Act that we're likely to see. So discussion open till the end of August. The process thereafter will be to consider that, make a final report on what the legislation should look like, and then draft a bill to go before Parliament, and at the same time then start the complicated process of drafting all of the regulations, remembering that the WA bill is to cover both general work health and safety, the mining regime, and ultimately dangerous goods. So there's a bunch of work in terms of drafting the regulations to make it all work for all of those different industries. So lots still to happen in WA in terms of getting the new laws across the line. I think that's it. Looks like there's a bunch of questions, Gregory. Did you want to field those?
Yeah, I'm just thinking I might just mute you for a second. I think we've got time for questions, but I'm thinking like some people might like to go. So if I can just sort of do a bit of a plug at the end, and it may help people to keep up to date as well. So Sam has an excellent monthly e-newsletter called 60 Seconds with Sam, and you can stay abreast of all these latest developments, some of the things he was talking about, how firsts in terms of prosecutions. It's an excellent newsletter, which you can just go to this website and you'll get that sent to your email. I strongly support you do that. And also, I work for ECU, and we'd love to have you on board with us as a student. So you can get various degrees in terms of graduate certificates, graduate diplomas, and master's degrees, and industry-based pathways into the postgraduate courses as well. So it's all online and flexible and internationally accredited. So look forward to if you have any questions about that. But yes, okay, so let's maybe if Sam, if you can go back to those questions. Those who have to leave, you're welcome to leave. And Sam, if you want to field those, I'd be happy to sit in the background.
No problems. Thanks, Gregory. So who tends to propose the program for an appropriate enforceable undertaking? So thanks, Bill. Good question. Look, it is entirely in the hands of the person that's making the offer for the enforceable undertaking. So it's the person that has been the alleged offender that would put forward the proposal to the regulator to say, this is what we have in mind. And does the regulator think it is a good idea to then accept as an enforceable undertaking? Now, typically what happens is that there's some negotiation backwards and forwards between the parties. The regulator has a rule book that it plays by in each jurisdiction that accepts enforceable undertakings. There's an enforceable undertaking policy, so that will set out some general parameters that you have to meet. Things like you can't enter into an enforceable undertaking if the offence has resulted in a fatality, those sorts of parameters. But otherwise, it's completely open to the person putting forward the proposal to say, this is what we think is going to achieve good safety outcomes. And that's why you see such a variety of enforceable undertakings accepted. You know, some of them have a particular project that they throw sort of all of their money behind one particular project, and it might be, developing a new training course for their people that they will then roll out more broadly, or it might be developing guidance around a particular risk that is known within the industry and developing some communication tools around that, something that the regulator can't itself fund. Or it might be a whole range of projects. So you often see enforceable undertakings that include, charitable donations and support of local community groups, et cetera, et cetera. So it's pretty open, it's pretty flexible, as long as it demonstrates that there is a tangible safety benefit. And it has to be something that goes above and beyond compliance with the Act. So you can't just fix up the problem that you're alleged to have had in the first place. It's got to be something that goes above and beyond. I think there was a question about the stats, and I think somebody jumped in and answered that, which is dead right, that the information that I quoted from is from the annual reports of those regulators. Those are generally a really good source for that sort of statistical type stuff. The annual reports of each of the regulators talk about what enforcement activities they've undertaken. Some of them have some examples of prosecutions that have been successful in that year in them. So they're a really good source if you're looking for that sort of data. There's obviously a bit of a lag to it because the annual reports, talk to the previous financial year typically, but it gives a pretty good steer as to the enforcement activity that each of the regulators is up to. I think there is also a national report that is published by Safe Work Australia that does talk about the statistics across all of the regulators. I can't remember off the top of my head whether it gets into statistics of number of notices issued, but I think it does try and provide a bit of a snapshot as to the regulatory activity across across all of the regulators. If you drop me an email, I can dig out the link for it to you. I just can't remember what it's called off the top of my head. Yeah, Bill, so is it the legal team or the business themselves that would initiate an enforceable undertaking discussion? Bit of both. Depends whether the person is represented. Typically, if they've been prosecuted and they're a larger organisation, they would be represented by lawyers. And so the lawyers would have considered the case and the merits of the case and would have given advice about whether it's something that is likely to be defendable or whether it's something that there might be an opportunity for an enforceable undertaking. And the lawyers would probably make the approach to the regulator, but the heavy lifting in terms of the idea about what the enforceable undertaking is going to be, what the project for the enforceable undertaking is going to be, would be driven by the business, and the lawyers as the pen pushers would really just do the drafting and framing that up into the document that is ultimately entered into. Because these things, if you've ever looked at them on the website, they look a bit like a contract. It's an agreement between the alleged offender and the regulator to undertake to do certain things. So because they're a legal commitment, the lawyers typically get involved in drafting them. How do we go about making OHS laws relevant and easier for us to all to understand? Well, look, I guess the regulators have a constant battle in terms of doing that. The regulators would say that there is guidance material out there that tries to distill all of the legal obligations down, but I take the point that when you're dealing with, 600 odd pages of regulations in the model regulations, it's not an uncomplicated area. So it is an eternal struggle to make all of that stuff simpler and easier to digest. Codes of practice and the guidance materials are helpful, but I think there's still a long way to go, particularly in communicating to people with low literacy levels or people with English as a second language. And so, creative ideas, I think, are really welcomed both from a regulatory perspective, but also in your own workplaces, that if there are opportunities to communicate in new and different ways and make use of technology that uses, videos, etc., I'm all for that, and I think the regulators are coming on board more and more with that type of thinking, that no one wants a health and safety management system that is just a whole bunch of paper. You need to have instructions that people understand to undertake the activities that they're undertaking. So if you can do that in a constructive way, in an innovative way, that would be wonderful. Sorry, guys, I've lost track a bit with the questions. Let me just scroll back up. Sorry, Bill, that's a long question. Let me come back to that one. Good question, Georgina. How long are we likely? How long is it likely to be before we see the laws in WA? Look, I think the word on the street is sometime mid 2019, but I've been doing this game for a long time, and I'm certainly not holding my breath. Every time I have this conversation, WA seems to ebb and flow a bit. So I feel your frustration. 2019 is the word on the street, but let's wait and see, and hope that we don't have, political will lost by a change of government. Okay, so sorry, Bill, bear with me whilst I just read that question. Yeah, look, agree with all of those comments, Bill. I think they're all valid concerns that could well impact on insurance for those people that are providing that advice. Look, I think if there's comments, I would be making them back to the Department of Mines, Industry Regulation and Safety, as it now is, by way of feedback on that public consultation piece, because certainly the fact that it's been put in the discussion paper doesn't mean it's a done deal. The more feedback that they get on the risks that might be associated with introducing that duty, the more likely it is that that wouldn't be included. So, look, all I can say is if you've got comments and concerns on that, feed them through and take the opportunity to provide the feedback, either directly or through any industry body or association that you're a member of. I think that's it, Gregory. If there's any more, then
there's a question by Christian. Are there legal practices this business matter?
Sorry, what was the question? Have I missed one? Are there legal practices to assist businesses? I mean, so I think, and jump in if I'm not understanding the question correctly, Christian, but is the question about are there people that help to look at legal risks in a proactive way? Yes, there are. Myself and my firm, and other firms included, that we advise on how to comply with the laws proactively, as well as getting involved when things have gone wrong and defending organisations that have allegedly committed offences. So there are lawyers that help from the legal side and interpreting the laws, and there are, of course, a range of work health and safety consultants that are specialists at advising on risk and how to deal with risk and navigate risk. And there's also other resources around that are free resources. They're not as targeted and as tailored, obviously, but the regulators do put out a range of guidance material that is designed to help assist people comply with the laws. But yes, there are organisations out there that will help you through issues and help you identify how to go about proactively complying with the laws.
Okay, so I think that's it. So
That's it.
I think we
So
can probably
I
end
think
things there.
probably end.
So thank you everyone for participating tonight and joining our webinar. And like I said, if you have any questions, just please feel free to contact us. And this recording will be provided to the Safety Institute of Australia. So hopefully if you want to go through it again, you'll have that opportunity, and those who are just listen to the recording as well. All right, so thank you to everyone. Thank you, Sam. And we'll end the recording. Feel free to leave the virtual room now. Thank you.